Well, we've talked about the rights that the First Amendment offers, but now we need to take a look at some of the limits that have been placed on it by the courts in interpreting that First Amendment. Democracy is a kind of a quirky thing in the sense that we have to have the right to criticize government leaders in order to have a democracy, but ever since we were granted that right to free speech, we were also had some limits put on it. The Alien and Sedition Acts were the first real kind of constraints that were put on the First Amendment. And you see, it was in 1798, so it wasn't very long after it was passed that we faced that. The Federalist Congress basically said that there was not going to be a way to put false publications against the United States or anything that was malicious or scandalous, and of course that was open to interpretation. The fine was $2,000 and up to 2 years in jail, which was pretty stiff penalty in 1798. But you can see not long after, less than 20 years later, we had the Espionage Act, which was considered to be even more grievous, which were any attempts to cause insubordination or disloyalty, mutiny, refusal of duty in the armed forces, and this was punishable of 20 years in jail and $10,000 fine. Just a year later, the Sedition Act came in, and it amended the Espionage Act, and this said specifically that you couldn't interfere with the recruiting process for the armed forces, and I'm sure you can guess that World War I was a pretty big factor in the passage of this. And it didn't take long. We had only just about a year until we had our first court case that challenged this, and this was Schenck versus United States, because during World War I, Schenck mailed circulars to draftees, and he did exactly what the act was intended to prevent. He said that the draft was wrong and motivated by capitalist system, and he wanted people not to submit to the intimidation. So he was charged with conspiracy to violate the Espionage Act, and really the question that the court had to decide was, were his words protected by the First Amendment in terms of being free speech? And what they decided was no. Based on the Espionage Act, Oliver Wendell Holmes cited this, and he said that in every case it's whether the words are used in such circumstances and are of such a nature as to create a clear and present danger. And that became a pretty big kind of rallying cry from a court standpoint, this clear and present danger, that there were certain things that during peacetime we could tolerate, but during wartime we couldn't. We were faced a bit later with the Smith Act, and that made it a crime to advocate the violent overthrow of our government or to organize any kind of group. Now, the Supreme Court ultimately decided that this was not necessarily going to fit within the framework of the First Amendment when it heard the case of Yates versus the U.S. and agreed that Communist Party leaders were allowed to advocate what they wished, because speech was speech, and that didn't necessarily correspond with action. Now, this idea of the clear and present danger is, will the speech create a dangerous situation? What exactly are we going to be faced with? And the First Amendment really doesn't protect things. So one of the things that we hear about often are such a thing as fighting words, words that you can't say in a way that will incite people to action. So we'll hear about yelling fire in a crowded theater, which of course, unless there is a fire, that's going to be a problem, that you're inciting people to do things that doesn't necessarily get protected by free speech. Now, where this came up, we had the case of another speech case with CHAPLINSKY versus the state of New Hampshire. And basically, he called a city marshal a goddamn racketeer and a damn fascist. He was arrested and convicted under violating the peace. And the question was, does the statute that prevented this violate his right to free speech? And the law was actually upheld. This idea, again, that some forms of expression do not convey ideas, they do not contribute to the democratic process, and so they are not subjected to the First Amendment protections. And these were considered to be those fighting words that we talked about. Now, another case that took place right here in the great state of Ohio was Brandenburg versus Ohio in 1969. This was a case where Brandenburg made a speech at a KKK rally, and there was an Ohio law that made it illegal to advocate, as you can see here, crime, sabotage, violence, or unlawful methods of terrorism. Now, the question before the court was, could this Ohio law that prohibited speech actually fit within the framework of the First Amendment? And in this case, the Supreme Court found for Brandenburg, and what they said was that the law was overbroad and it violated Brandenburg's right to free speech. They actually established a two-part test that would evaluate whether or not a speech act like this would be allowable under the First Amendment, and it said that speech can be prohibited if it's directed at inciting or producing imminent lawless action, or is likely to incite or produce such action. And they found that in this case, that was not the circumstance, and that this law, again, was overbroad.